Good evening to you all, those of you assembled in the Middle Temple Hall, and those of you joining us online, over 100 in number, I'm told. Welcome to this second event in a series to mark the 450th anniversary of the completion of the hall. I can think of no better way to mark this important anniversary than the lecture we are to hear this evening. One of my proudest boasts is that when I was an undergraduate at Cambridge, it was some years ago now, I was taught legal history by John Baker. He was then, I believe, in his first year at Cambridge as a fellow of St. Catherine's College and as librarian of the Squire Law Library. Professor Sir John Baker, Downing Professor of the Laws of England, as he became, is a legal scholar of immense distinction. He's one of the greatest legal historians this country has produced. His subject this evening is the Middle Temple Hall and the Elizabethan rule of law. John, we're delighted that you're able to be with us, and we greatly look forward to your lecture.
Excuse me. Master Treasurer, it's an enormous privilege to be asked to give this lecture in this wonderful hall, which in its day was one of the architectural wonders of London. And so it still is, 450 years later. It was the largest of any of the buildings in the Inns of Court, 30 feet longer than Gray's Inn Hall, which was completed in 1560. Evidently a costly enterprise, it was a bold one, given that the Templars were then only tenants at will of the Crown and had no title deeds. It replaced a small medieval hall on the other side of the lane in the region of Elm Court and Pump Court. And that may be the explanation for the adjective middle, because the original hall was right in the middle of the temple. And the existence of two halls before the lawyers came also explains why there were two Inns of Court formed in the temple in the mid-14th century. Halls were not only a source of food and warmth and good fellowship for a resident community, but also a venue for lectures and moots. They're all the essential prerequisites for a learned society. In the 15th century, the Middle Temple had been the smallest of the Inns of Court, drawing much of its membership from the West Country. But by the 1560s, its fortunes were changing dramatically. The 4 Inns of Court and the 9 Inns of Chancery, which some called the Third University of England, were burgeoning. By 1560, the annual admissions to this inn alone were approaching 70, and new sets of chambers were springing up, including in the 1560s Brick Court. The Elizabethan poet Edmund Spenser, musing on the River Thames, referred to these buildings as those bricky towers the which on Thames broad aged back do ride, where now the studious lawyers have their bowers, there whilom wont the Templar knights to bide, till they decayed through pride. With the explosion of numbers, the old hall must have become woefully inadequate. And in 1562, the decision was made to replace it with a large new one in the gardens on the opposite side of the lane. On the 23rd of June, 1562, Edmund Plowden wrote to Sir John Thynne at Longleat House in Wiltshire, informing him that the masters and fellows of the Middle Temple had appointed his chief carpenter, Lewis, to work on the building and asking for his favor. It's an interesting letter, a copy of which I think is on display somewhere in the inn, possibly in the library. The letter says that Lewis had previously been employed on the Queen's works and that the Middle Temple Hall was also the Queen's Highness's house and work, presumably meaning that the Queen owned the freehold. Incidentally, Plowden thought it politic to add an apology for having been engaged professionally against Thynne in the past, promising that he and his fellows would give him their friendly furtherance in his lawsuits in the future. Plowden wrote that letter as treasurer, and he was clearly the driving force behind the project. Renowned as one of the most learned lawyers in England, he had been struck from the new list of sergeants in 1559 on account of his backwardness in religion, and deprived of the coif, he was thereby also debarred from the bench. But the inn was more forgiving, and after his death in 1585, when recusants were being prosecuted with vigor, he was not only buried in Temple Church, as he requested, but given the finest of all the monuments there, a reward, it must be supposed, for his untiring efforts in this spectacular building project. I'm staring at him as well over there, but I think that's a much later bust based on the monument in church. He served for 6 years as treasurer and then continued as collector for the new hall until 1574, when the screen was finished. Sometimes the completion of the building work has been dated to 1570, because that's a date in the east window. But the window is from the 19th century and it carries no credit. John Stowe, writing in 1598, gave the date as 1572, which would of course include 3 months of 1573 in the new style. And it seems clear that the main work was indeed completed in 1573, so we've got the right year. On the 13th of November, 1573, the old kitchens were granted away, and soon afterwards, the old hall itself, which remained in being until 1639, was converted into chambers. Plowden's armorial window up there somewhere says, "Hoc perfecit opus." He brought this work to completion, and then the date 1573. And it adds that for this achievement, he deserves to be honored for all time. Well, 450 years is a good start. As you can see, the hall was constructed in the medieval manner with Renaissance ornament in the detail, which is perhaps a metaphor for the common law of that period. The windows were filled with the coats of arms of members who had contributed funds. Almost all the original panels remain, remarkably, 120 of them. It wasn't a new idea to decorate hall windows with the arms of eminent members and benefactors. Lincoln's Inn and Gray's had been doing it since the 1490s, but this was by far the largest display, the finest in London, frequently studied and catalogued by antiquaries for centuries. The painted wooden panels around the walls with the arms of readers were not part of the original scheme. They began to be installed in 1697, when the first batch was moved from the Parliament chamber. And it was a practice begun by all the inns in the 17th century. While I'm on architecture, I should mention that the entrance clock tower was another addition to the original scheme in the 17th century, then redesigned twice as tastes changed. The Louvre in the roof, which I don't think you can even see from down here, but perhaps you can. You can see it from outside anyway, also underwent successive changes to make it more decorative. But it's a reminder of the fire which until the time of George III used to warm the hall from a hearth placed centrally beneath it. And as in the other inns, the hearth was a focal point in hall. Focus, of course, in Latin means a fireplace. And we hear of mooters arguing fire cases in the Elizabethan period. Well, it was an ambitious building project. It seems that no expense was spared, even when there was no money in hand. We don't have the accounts, but as a comparison, it's estimated that the hall of Trinity College, Cambridge, which has the same dimensions, it's about 101 feet by 40 feet, I'm told, cost nearly £2,000 in 1605, which is about £500,000 in today's money. And the funds were raised from members. Their open-handedness seems impressive, but it wasn't purely voluntary. In 1566, those who had failed to pay towards the hall were ordered to be expelled from their chambers. Just a little pressure. And in 1571, there was a forced loan. Benchers were to lend £3, barristers £2, and others £1. And I dare say, as with the Crown's forced loans, none of them were ever repaid. When Plowden finally stepped down in 1574, the books were still unbalanced, and chamber rents had to be increased to try and reduce the deficit. But these Elizabethan lawyers built to last, as you can see, and the hall survived the vicissitudes of time remarkably well. In 1922, the roof was found to be infected with death watch beetle, an enemy which may in previous centuries have been kept at bay by the smoke from the fire. See the dangers of innovation. The credit for discovering the beetles has been given to the newly admitted women members who protested at insects falling into their dinners. The men apparently hadn't noticed. Upon investigation, it was found that the woodwork wasn't quite the masterpiece that had been supposed. It had been faultily constructed, and the walls had pushed out by 10 inches over the years. So much restoration and renovation was carried out in the 1920s and 1930s. And this essential work was then nearly undone by human enemies. On the outbreak of the Second World War, the stained glass and the armor, the panels and portraits were, thank goodness, removed for safety to the country. But on the 15th of October, 1940, a parachute mine destroyed Fig Tree Court and blew an enormous gash in the east gable of the hall, extending from the gallery up to the roof. And it threw the oak screen onto the floor, smashed into smithereens. The fragments with the beautiful carvings were carefully collected and sent in 200 sacks to Ludlow so that the puzzle could be reassembled after the war. And what a marvelous job they did. You wouldn't know if you weren't told. Incendiary attacks in 1941 and 1944 damaged the roof, but miraculously most of the hall remained intact, thanks not only to the intrepid firefighters, but also to the underpinning and strengthening which had just been carried out. The inn lost its Victorian library, of course, completely, but it fared better than the Inner Temple, which lost its stately Victorian Gothic hall and library in the same air raid of 1941, which destroyed about half the temple, and Gray's Inn, whose Tudor hall was reduced to an empty shell. All that devastation was wrought during 2 or 3 air raids, and had Hitler not diverted the Luftwaffe towards Russia, the whole of legal London might very shortly have been destroyed, along with much else of our national heritage. But here the Great Hall still stands, much as it was in its Elizabethan heyday, with a few extra embellishments. Soon after its completion, the hall was being booked as a spectacular new venue. By the 1580s, it was in use for select committees of the House of Commons, which in those days were replete with barristers. It was also chosen for the General Call of Sergeants at Law in 1577, a ceremony of considerable magnificence. The 7 graduands received their coifs and scarlet hoods from the Lord Chief Justice, standing more or less here, I suppose, in the presence of the judges and all the company of the houses of court and chancery standing round about them. And later the same day, the tables were laid, and the sergeants provided a magnificent feast here. They and their guests managed to consume 38 gallons of sack, 25 gallons of claret, 19 gallons of Rhenish, 9 gallons of muscadet, 10 barrels of ale, And I won't take you through all the menu, but the costliest of delicacies, including gilded fish and jellies. The total bill came to about £250, which is about probably more than 10% of the cost of the hall itself. And each sergeant had to contribute over £12,000 in today's money for the feast, and a similar sum was spent on robes and gold rings to distribute as largesse. Such was the grandeur of the law in the time of Elizabeth I. On a less grand but equally notable occasion, the following year, the hall was honoured by a visit from Queen Elizabeth on the 3rd of March, 1578, the first recorded royal visit to any of the Inns of Court. The event isn't mentioned in the Inn's records because it was impromptu and, as it turned out, deeply embarrassing. The details were discovered only recently in a manuscript in the British Library. The Queen was staying with Robert Dudley in Leicester House, not the later house of that name in Leicester Square, but the one near the entrance to the Middle Temple. And without forewarning the inn, she decided it would be entertaining to wander down the lane and see the new hall and watch a lecture in progress. And although she told the reader and students to carry on as normal, she was just an old gentlewoman come to see their exercise. The whole company was struck dumb and unable to speak, let alone to show the proper courtesies due to a monarch. That we learned that the reader died the following year, and I wonder whether it wasn't a result of this experience. Her Majesty probably didn't miss much. It was a dull reading on joint tenancy, and not many members were present. Had she made the visit 5 months later, she would have had a very different experience, because the autumn reading of 1578 was one which still excites academic interest today. And that brings me to the second aspect of my talk this evening. You may have been wondering what the connection was, but there is one. The autumn reader was James Morris, a member of Parliament belonging to the wing loosely labelled Puritan. It's a misleading epithet because it covered a wide range of nonconformity. The purest of the Puritans wanted to do away with bishops, priests, and religious ceremonies altogether, but there was a less extreme nonconformist wing within the Anglican clergy, parsons who refused to wear surplices and disliked the Book of Common Prayer, disapproved of wedding rings, and so on. I suspect they were the kind of people who said grace before dinner in English. Their somewhat Bolshevik libertarianism spilt over into secular politics. The so-called Puritan members of Parliament, nearly all of them barristers, were keen on Magna Carta and what it represented as a guarantee of personal liberty. They campaigned vigorously against abuses of the royal prerogative and against the creation of new jurisdictions outside the common law system, especially the Ecclesiastical High Commission, which had assumed sweeping powers since 1559 and was evicting Puritan clergy from their benefices, flouting the authority of the patrons who put them there. They also contested the all too frequent instances of arbitrary imprisonment by courtiers, aristocrats, and the increasing use of patents of monopoly to increase revenue without parliamentary sanction. Of course, they could only campaign as MPs while Parliament sat, and Parliament didn't in those days sit continuously or for very long. And the Queen was apt to prorogue or dissolve it promptly if any contentious issue flared up. But the common law could not be dissolved or prorogued, and the law offered a promising armory for a different line of attack. And the reason for my choosing the talk on the subject this evening is that the leaders of the expeditionary force were all Middle Templars. I should set the scene by traveling back 20 years to the period around the time Hall was built. Public law hadn't featured much in the medieval and early Tudor law reports. The first case of significance concerning personal liberty concerned, as it happens, another Middle Templar, or erstwhile Middle Templar, Humphrey Brown, who had left the inn on becoming a sergeant at law. This was compulsory. He, in 1532, was sent to prison on the orders of Henry VIII for advising prisoners in the Tower to give away their goods to avoid forfeiture. And he'd also engaged in a bit of illicit hunting in Waltham Forest, but he wasn't charged with any offence. And upon his release, he complained to the Privy Council, who called in the judges. And the judges, quite correctly, drew attention to chapter 29 of Magna Carta. No free person shall be imprisoned or dispossessed or mistreated except by the law of the land. And they agreed that the king could not treat his subjects contrary to law. And they said that whether the cause of imprisonment was a good one was a matter of law. Well, so far, so good. And that was bold enough when they're referring to Henry VIII. But then they conceded that there could be no scrutiny of the cause because there was no way of questioning in court an imprisonment by the king's discretion. The report wasn't published until 1976 anyway, but it illustrates the practical weakness of Magna Carta. For all its fine phrases, it didn't spell out any remedy. If the king or his ministers incarcerated someone off the record, they could not be sued. Well, that was in the time of Henry VIII. By the time that this hall was built, the atmosphere was changing. A growing interest in constitutional matters was welling up, certainly here in the Middle Temple. The reinvention of Magna Carta, as I called it, was closely associated with William Fleetwood, Recorder of London, who became a bencher in 1564. And besides his many public activities, he wrote a number of books, which he circulated in draft but never published. The first of these was a commentary on the Great Charter, and he never lost an opportunity thereafter to cite it. As Sergeant Brown's case showed, it had not been forgotten, but it was seldom mentioned in legal argument and was thought by many to be a historical curiosity of little practical use, rather as it is today. Fleetwood tried to reawaken its potential. As he was fond of saying, it was won by blood and had been confirmed 30 times by successive kings. And although parts of it had been repealed, its essential principles were permanently entrenched. And that was because no monarch could inherit more than his predecessor had left. And what the kings of England inherited was not an absolute monarchy, but a constitutional monarchy, immutably circumscribed by chapter 29 of Magna Carta, which their predecessors had repeatedly confirmed. Well, that must all have been familiar learning to Middle Templars by the time James Morris gave his lectures in 1578. He chose for his text a brief section at the end of a statute of 1275, saving the rights of the crown. It's really just a saving clause. But he said, well, what were the rights of the crown? Previous lectures on the prerogative had addressed only the feudal prerogatives, the property rights of the crown. Morris started out in a new direction by lecturing on what we would call public law. The text enabled Morris to emphasize his loyalty to begin with by lecturing ostensibly on the royal prerogatives, beginning with a spirited defense of constitutional monarchy as preferable to democracy, which was understood by him in the Greek sense of direct democracy, referendums and that sort of thing, which in his words were the government of the inconstant, rude and ignorant multitude. But he insinuated his main points as qualifications to be read into the saving clause. It was the first principle of constitutional monarchy, according to Morris, that the king could not abrogate or change laws without the consent of the ruled. It followed that the king could not, by letters patent, charter or commission, make new law which affected the lives or property of his subjects. It was true that he could grant or confirm positive rights, as with Magna Carta, but he couldn't alter the law or levy money for the necessary affairs of the realm, save through Parliament. These issues were going to dominate the House of Commons over the next 50 years. But what is important, I think, about Morris's lecture is that he treated them not as questions of politics or political theory, but common law. The other great issue of the time, of course, was religion. And Morris tried to bring that within the scope of the common law as well. He held that the king was supreme governor of the Church of England by the common law, not by statute of Henry VIII. There were sources going right back to Magna Carta itself, which he could cite. He argued that the church could not make new laws to bind the laity without the royal assent, and that the church courts were subject to the king's governance. He didn't explicitly mention the High Commission, perhaps that was a politic omission, but it was an obvious deduction from what he said that the commissioners of any kind could not imprison people or deprive them of their livings without clear statutory authority. And there will be a great deal of argument in the courts in the following decades about the vagaries of the statute setting up the High Commission. In 1593, indeed, Morris himself was to present a bill in Parliament to reform the High Commission, reciting Magna Carta, but the only result was it earned him 2 months extrajudicial imprisonment. I don't think the judges would have locked him up. They were very sympathetic to the cause, but not so much the Queen. Well, Morris's lecture is full of important ideas about the Constitution. I won't go on about it any longer. It is at last, all these 450 years later, being edited for publication by an Italian professor. 3 years later, in 1581, Robert Snagg, again standing here where I am, took up the theme more directly by lecturing on chapter 29 of Magna Carta. It was the first known reading in any of the Inns of Court, simply on chapter 29. It nearly didn't happen. The benchers wanted to pass him over when his turn came because he'd been a thorough nuisance in the inn and had on several occasions been insolent to the benchers, and including Fleetwood, and had been put out of Commons. His arms don't appear in the windows. However, he was supported by Lord Burleigh and the benchers had to give way. Unfortunately, only a small part of his reading has survived. It is evident that legal history was at its core. Snagg said that the common law was immemorial in its essential features, but it had been disturbed by the Normans. And then Henry III, who in Snagg's words, had been by diverse descents purged and purified by our English air, and by education after the order of our nation, and so become English, and of a better nature than the aliens and their offspring. He allowed Englishmen their English laws by issuing Magna Carta in 1225. No mention, you see, was made of the awful King John, who'd gone to great lengths to have the 1215 Magna Carta annulled by the Pope. Nor, incidentally, was Magna Carta mentioned in Shakespeare's play about King John. Magna Carta was always dated to 1225, and we've got the anniversary coming up in 2 years, the year it was deemed to have become statutory. And we can guess that Snagg's lectures were an elaborate encomium of Magna Carta along the same lines as Fleetwood, invoking a measure of national pride, greatly overstated, no doubt, to our present taste, in what was becoming an iconic document. By the late 1580s, Magna Carta had entered everyday legal discourse, and chapter 29 was being regularly cited in court, not just by Puritan counsel, but even by conservative judges. It just caught fire. However, the great problem which Fleetwood, Morris, and Snagg did not address was how to give practical effect to chapter 29, given that the king could not be sued. And the answer was found in the writ of habeas corpus. a link which was made in the courts rather than in the lecture room. The immense power of habeas corpus resulted from there being no defendant. Unlike false imprisonment, it wasn't an action between parties with pleadings and delays and eventually a trial long after the event, but it was an administrative order to a jailer to produce a body at once, together with the reason for the imprisonment. And it therefore lay, even if the imprisonment had been ordered by a minister of the Crown. And it put the reason on the record so that it could be reviewed. And since all the power of government depended in the last resort on the ability to imprison people, this new device made it possible for governmental decisions to be challenged in court. It was the beginning of judicial review as we know it. Habeas corpus was soon followed by mandamus and certiorari, which operated in a similar way, but were originally aimed at local government. It was a bold step for the judiciary. How could judges appointed by the king, holding office at pleasure, king's pleasure, place effective limits on the king's authority? The medieval answer to that question was that the king can do no wrong. So anything unlawful done in the king's name was void because the king could not be supposed to have authorized it. But there's now an ingenious new extension of this theory. The writs of habeas corpus, mandamus, and certiorari were categorized as prerogative writs, a new term of art then, which we've only recently given up. And although they were in practice often used to challenge a prerogative, they were represented as the means of exercising a higher prerogative, that of keeping all authorities and jurisdictions within the law. That was the proper role of the King's Bench, according to the new theory, because this was the Supreme Court of the day, the King's own court, notionally held before the King himself. It was a theory most famously propagated by Sir Edward Coke, first as Attorney General and then as Lord Chief Justice under James I. Coke went so far as to say that the King's Bench had authority to correct any manner of misgovernment. That got him into an awful lot of trouble, including dismissal from the bench in 1616. But the idea stuck, and we now take it for granted. However, we're concerned this evening with the beginnings, and they're not nearly as well known. They're revealed in the long unpublished notes of the three chiefs at the beginning of Elizabeth's reign: Sir Robert Catlin, Chief Justice of the King's Bench, Sir James Dyer, Chief Justice of the Common Pleas, and Sir Edward Saunders, Chief Baron of the Exchequer, all alumni of the Middle Temple. And their names and arms will be found in the windows, as will Snaggs, if you have good enough eyesight to pick them out. In 1559, both Dyer and Saunders made detailed notes, which we still have, of a case which set the judges thinking. A senior clerkship in the Court of Common Pleas had been unlawfully granted by Mary I to a military person, while the Chief Justiceship was vacant. The gift of such positions normally belonged to the Chief Justice. The court rejected the grantee because he was an untrained layman and admitted one Scroggs, an attorney. The Earl of Bedford and Lord Dudley, who were behind all this, then obtained an unprecedented special commission to determine the title to the office on the grounds that it was a freehold, with power to commit Scroggs if he refused to cooperate. Well, Scroggs didn't cooperate, and he was committed to the Fleet Prison for contempt, and he applied to the Common Pleas for his release. And Chief Justice Dyer considered using a general habeas corpus, and he actually managed to find an unreported 15th century precedent of this, although it's not known actually to have been used. But since Scroggs was an attorney, he was able instead to release him on a writ of privilege, which was a special form of habeas corpus for officers of the court. Didn't do Scroggs much good because he was immediately rearrested by the commissioners, and he remained in close custody for over 5 weeks. The judges were appalled by this. They regarded it as a major affront to the law and held the commission void in law. It was all in the end settled without a judgment. Now, those unsatisfactory proceedings almost certainly explain why Chief Justices Dyer and Catlin immediately began collecting and sharing precedents of writs of habeas corpus, whereby judges in the past had discharged or bailed prisoners committed by statesmen. The first example they found was in 1518, when someone incarcerated by Cardinal Wolsey was first bailed and then discharged. The background was unclear because the details were not entered on the record, but it was enough that the return, showing a commitment to prison by the Lord Chancellor without any other cause shown, had not precluded a grant of bail and a release by the King's Bench. That was all they needed. And Dyer even found a case where the judges had overturned a committal by Thomas Cromwell, though they only performed this brave feat shortly after Cromwell's execution. These weren't reported cases. They were precedents in the manuscript rolls of the Crown Office. The roll merely recorded the return and whether the prisoner was released, bailed, or remanded. Now, no doubt there was much more to each case, but it was invisible. And that was the great value of these precedents, that the record was enough to show that the court had the power to release prisoners simply with reference to the return and whether it was good or not. And Dyer and Catlin both perceived that this gave habeas corpus a potential which had not been realized before. And I just mentioned 2 of the earliest cases, maybe it's 3. This newfound potential was brought to bear in 2 cases in 1565. The first was that of John Lamburn, who was imprisoned at York. And when Lamburn obtained a writ of habeas corpus, the sheriff returned that he'd been told by the Archbishop of York, who was president of the council in the north, to disobey the writ. The King's Bench then not only ordered a second habeas corpus, but also a writ of attachment against the Archbishop himself. And Chief Justice Catlin remonstrated forcefully. He said, "In this court we hold pleas before the Queen herself, because this is the Queen's highest court, and it is of such dignity that in whatever prison a man may be, we may command the officer to bring him here. Even if he's a prisoner in the Tower by command of the council, we may send for him here by writ of corpus cum causa, directed to the constable of the Tower." What the reports don't mention is that Lamburn was a criminal who turned Queen's evidence against some robbers and was awaiting a pardon. But that wasn't the point. Those facts didn't appear on the roll because there was no return. It was for the King's Bench to decide on the lawfulness of the imprisonment, and without a proper return, they couldn't do so. So another useful precedent had been set. The other case, in 1565, provides the first instance of habeas corpus for a prisoner of the High Commission. A Shropshire gentleman had been imprisoned for hearing mass, which was then an indictable misdemeanor, and it was argued for the commissioners that they had the power to imprison without bail at their discretion. The King's Bench disagreed, and they released the prisoner, but he was promptly rearrested. And here was another example of high-handedness, which greatly annoyed the judges. But 3 years later, another Roman Catholic prisoner of the High Commission, who had refused to incriminate himself upon the oath ex officio, which was an sort of ecclesiastical 3rd degree, was released upon habeas corpus. It was the first clear decision affirming the privilege against self-incrimination. Only the clergy could be forced to answer questions about their beliefs. And as the Queen herself remarked, there was no need to make windows into men's hearts and secret thoughts. The common law, unlike the medieval canon law, simply didn't allow it. After that, habeas corpus was in regular use in the King's Bench, not only against prerogative courts, but against individuals who abused their position. Some Elizabethan noblemen got it into their heads that they could just lock people up, sometimes in secret places where habeas corpus wouldn't even run, to coerce them to do their bidding in private matters. And it came to a head in 1592 when John Agmondisham, I think it's pronounced Amersham, another bencher of the Middle Temple, arms and window, no surprise, another Puritan MP, was unlawfully imprisoned by Lord Hunsdon, Privy Councillor. And the judges were so outraged that they signed a petition, all of them signed a petition against such abuses. Very unusually proactive judicial procedure, but it worked. The Queen and Lord Burleigh backed the judges on this occasion, so a new atmosphere was developing. Habeas corpus still couldn't be used to discharge someone committed by the Queen herself or by the full Privy Council, since it was assumed that in matters of state, such as treason prosecutions, the power would not be abused. Well, as we all know, that presumption collapsed in the next century when Charles I used imprisonment to enforce illegal methods of raising revenue. In the famous debates on the liberty of the subject in the 1620s, leading to the Petition of Right in 1628, habeas corpus was at the forefront. It was an efficacious new remedy which has infused new life into Magna Carta. But what is worth noting this evening is that the story began under Elizabeth I, and it was largely the work of members of this inn. In 1582, John Popham, as Attorney General, began an argument in the King's Bench by saying, every subject born and begotten in this realm has two privileges, one to inherit the inheritance of his father, and the other to inherit the laws of this realm, from which no subject ought to be barred, in confirmation of which is the Statute of Magna Carta, chapter 29, which is not changeable by the Queen. That was the Attorney General speaking. And as Lord Chief Justice, later on, Popham gained a reputation for what a contemporary called wholesome severity. But he was also a strong defender of habeas corpus and the rule of law. Another Middle Templar, another shield up there in the windows. In the 17th century, the torch passed to inner Templars, Sir Edward Coke, Sir Edward Littleton, and John Selden. And so it's appropriate, because time's running out, appropriate to keep this evening's story mainly within the Elizabethan period. But it's right to end by recalling the apotheosis of chapter 29 of Magna Carta in 1616. The occasion was another important reading in this hall, the reader being Sir Francis Ashley, third of the important lectures given here. None of them published, although substantial extracts from all three of them will very soon be published next year. 1616 was the year of Coke's dismissal as Lord Chief Justice, and the lecture was in effect, although it doesn't mention it, in effect a commemoration of all the decisions which had cost Coke his office. For Ashley, and doubtless for his nodding audience, chapter 29 was the law of laws, worthy, as Coke said, to be written in letters of gold. Everything worthwhile in the common law depended on it, according to Ashley. I'll just quote him. He said, by virtue of this statute, we have property in our goods, title to our lands, liberty for our persons, and safety for our lives. And every free subject may have a remedy for every wrong done to his person, lands, or goods. And not only so, for that would but give recompense for a wrong done. But this statute also prevents wrongs, for by virtue thereof no man shall be punished before he be condemned, and no man shall be condemned before he be heard, and none shall be heard, but his just defense shall be allowed. That was reading an awful lot into a few obscure Latin words penned 400 years earlier, but this was living law, striving for survival, not a history lecture like this one. Magna Carta and habeas corpus were the prime resources with which your forerunners in this inn, Fleetwood, Dyer, Saunders, Catlin, Popham, Ashley, worked to preserve the rule of law at a time when it was about to be put under severe strain. And I'll just wind up by asking whether any of this matters to us today. We hear it said that we've moved beyond history. We're free to create the world we want as we go along, unrestrained by the dead hand of the past. But no new law, however expertly drafted, can prevent despotism and revolution. What our ancestors understood, perhaps better than us, is the protection provided by a continuous constitutional monarchy, a monarchy which doesn't prevent change, but which ensures that changes take place and that government is carried on in accordance with the rule of law, constrained by the core principles of Magna Carta. It was an ancient and precious inheritance. It still is, not so much for the king, but for all of us. Like all inheritances, it can be squandered. But the Elizabethan lawyers who built this hall believed that history mattered. The Constitution rested on history, a tortuous history, admittedly, with failures as well as successes. But its core principles were becoming sacred. It operated on hearts and minds, producing a shared sense of civilized nationhood. And it could therefore achieve what courts and parliaments alone could not. And I leave it to you to consider how far they were right.
So John has very kindly agreed to take questions. Start with one that I've received online from one of the online listeners. It's Master Timothy Lloyd. Did the research by Chief Justice Dyer lead to the series of law reports under that name?
Yeah, well, Dyer's reports were reports of contemporary cases in which he was present, and so they were law reports, very important law reports. And he also left notebooks containing material which was not published in Dyer's reports because it was deemed to be too sensitive. And of course, that is the most interesting part of Dyer's reports. And I had the privilege of editing them myself a few years ago. And indeed, I relied on several of those cases this evening from his reports, which were left in manuscript.
And there's a question from Arwen May, who asks, were the Middle Temple benches supported by the other inns in these new and innovative steps? And he says it seems incredibly bold behavior.
I don't know of any evidence that any of the other inns disagreed. And it may just be chance that all the evidence falls out here. But that we don't know, because we don't have similar lectures to these in the other inns. We're just lucky that we happen to have these lectures. It may be that they were giving lectures next door on Magna Carta chapter 29, but history was not so kind to the other inns. But at any rate, Middle Temple is, well, seems to have been at the forefront.
Your lectures in Cambridge I too attended your lectures in Cambridge about 40 years ago, but as the subject was not supervised at that time, I don't think we ever actually met. If you take an interest in American jurisprudence, as I do, it's very striking how much habeas corpus and Magna Carta are still very present in their minds, in their jurisprudence, which is not the case, I think, here. What's the explanation, if any, for the curious desuetude, if I can use that word, of Magna Carta in the 19th century mind?
I'm not sure that I know the answer to that. It's more interesting to put it the other way around. Why is it being kept going so enthusiastically in the States? And Sir Edward Cook is a hero in the United States, whereas here he's regarded as a crabbed pedant who we don't have to take any notice of. And that's the fault of historians who didn't understand what Cook was doing. You know, when Cook said that habeas corpus is a way of enforcing Magna Carta, he didn't mean that it's actually mentioned in Magna Carta or that they had it in mind in 1215. Of course not, he knew his history. He was making a legal argument that Magna Carta said that no one may be locked up except by due process of law, must have intended that there should be some remedy. We found one, and that fulfills the intention of the makers of Magna Carta. So Cook has fared very badly, I think, from those who've completely misinterpreted it. Of course, he wasn't a very nice person. And there were difficulties about that. But I don't really know the answer to your question about why Magna Carta went. I think it went much earlier than the 19th century. I think it more or less obsolete by 1700 for practical purposes. And again, it was consigned to the history books. And perhaps somebody else will know the answer to that.
In the second row, and then
Thank you very much, Professor. My question was, if the writ of habeas corpus was rediscovered or a new life was given to it, what was its original purpose and why did it arise?
Well, it was originally, it was a writ for moving bodies around. And so it was used quite regularly in the criminal system to get somebody out of a jail in one place into a jail somewhere else, just to have the body there. It was the habeas corpus with the return of, with the cause of the imprisonment, which is the important one, is this special kind of habeas corpus. And as I say, Dyer did discover a precedent of such a writ in the 15th century for use by the common pleas, because the common pleas couldn't normally use habeas corpus. It was only the King's Bench. There are earlier examples of King's Bench writs, but not before about 1500. So the discovery was a bit earlier, but none of the cases were reported, and it didn't take off until Dyer and his colleagues went ahead with it.
Thank you for that very beautiful lecture, Professor. I just have a question. What one thing throughout the Middle Temple's vast history would you have wanted to, I guess, save? Like, for example, the Victorian Library or anything, like even down to the menus of the people who used to walk these halls. What one thing in history would you have wanted to preserve? And how do you think that might help us expand the knowledge that we have of Middle Temple or even constitutional principles?
Well, that's an interesting question. I take it from what you said after you asked the question that you're not referring to physical remains like the hall, because obviously that is the jewel of the inn in terms of physical survivals. Most of the lectures I'm talking about are not preserved here. In fact, the Inns of Court didn't keep copies of the lectures that people gave, unfortunately. So we're dependent on lecture notes, which have ended up all over the show. And most of those that I've spoken of this evening are in the British Library up in Euston Road. So those are important, of course, and those should be preserved, but it's not a matter of preserving anything in the inn. So I suppose I would say the hall is the thing to preserve, and that will remind us of the lectures that were given here.
Just thinking on the old debate about judicial creativity in the law and whether there is a cave in which the common law is all found and you're gradually finding things out of it, or whether judges are coming up with it on the spot. How many or how much of these bold changes that we see over this period do you think is coming out of an honest attempt to look to precedent, to look to the history of the law? or rather is just judges trying to step in either politically or more creatively?
Well, it's an excellent question. And it's one you could ask about any period, of course, including the present. The judges will always want to explain what they're doing in terms of precedent. And they were very keen on doing that in the period I've been speaking of. How do you judge what is a political decision? I mean, judges have got to decide what to do and try to do justice, which they're sworn to do. And if they see people flouting the law, and everybody accept that Magna Carta was the law, but people were flouting it. So what are we going to do about it? Well, there are precedents which we can use. And I don't know that that's disingenuous. I think it's true that nobody had thought of it before, for 400 years. But nevertheless, they were producing a just result without obviously changing the law. You could say that's just discovering the law from nowhere. And I suppose it does depend on whether we think the result is a good one or not. And that's our own judgment coming into it. The fact is, your question is such a good one that I'm not sure anyone can answer it, really. And that would be a book on how judges work.
Thank you. Are there the statute or repeals notwithstanding, are there any other historic acts that that might be as powerful or could have been as powerful and influential as Magna Carta was?
Not forgotten ones, no. The Parliament have been very busy repealing statutes. In fact, they repealed most of Magna Carta. They've actually been repealing the wrong bits of Magna Carta because they didn't realize that the 1225 Magna Carta had been held by the highest court to be a statute. And historians said, no, it isn't, because there was no parliament then. It depends what you mean by a parliament. But in fact, a lot of Magna Carta is probably still in force, but it wouldn't apply anyway because it's meaningless in the modern world. So there are 3 chapters in Magna Carta that are still in force. And I think everybody knows about them, but you would only cite them in court if you were desperate. And I don't think there are other statutes of that kind which contain broad general principles, but they're not, I think, going to light up any great new legal developments. It's the common law, of course, that is at the center of what I've been talking about. And what you do with statutes is also, to some extent, common law, because just reading the statute itself doesn't always tell you what it means, especially with a very old statute. It's got to be interpreted, and many statutes have been interpreted differently over the centuries. And that is a sort of common law. It's judicial decisions. It's not parliamentary. Parliament was only responsible for the words, the meaning we get from the courts.
So, John, I think I trump everybody here since you taught me legal history before you went to Cambridge. I'm rather wondering, how important do you think the collegiality of sergeants-in was in the judges' ability to come together to resist the crown? Because there, of course, they met in one unit as opposed to the 4 inns of court.
Well, I'm sure it was. Of course, there were 2 sergeants-ins. By and large, the common pleas judges tended to go to the Fleet Street Inn, just over there, and the King's Bench judges tended to go to the Chancery Lane Inn, which is just a blue plaque in Chancery Lane now. But I suppose that it creates even more of a, well, they could, of course, have met in their court or somewhere near it, but I don't think there were rooms that they could meet in apart from the court itself. So probably coming back to Sergeant's Inn was the equivalent of going into the judges' chambers at the court. Of Of course, that was important, yes. If they were only met each other when they were sitting on the bench, they wouldn't have had such important discussions. But we know comparatively little about what was actually discussed in Sergeant's Inn, as opposed to the cases that were argued by counsel in Sergeant's Inn, which is rather different, because it was private. And we do have some of these private discussions, the sort of thing they left out of Dyer's printed reports, but we don't have nearly enough of them to know exactly what went on. And we don't, as far as I know, have discussions in Sergeant's Inn about this sort of thing, probably because some of it might not have been very wise to put into writing.
Thank you, John. Thank you very much for a brilliant lecture this evening. Your audience this evening is made up almost entirely, not entirely, but almost entirely of Middle Templars who are devoted to this society, to its history, and to this hall. But I venture to suggest that every one of us will have learnt a great deal from your lecture this evening. You very successfully transported us back to the late 16th century, and you've told us a really fascinating story. It's very pleasing to learn that just as the Temple Church played a part in the making of Magna Carta itself, this hall and the Middle Templars who then inhabited it, people like James Morris, Robert Slagg, and Francis Ashley, played a part in the reinvention of Magna Carta, of which you have so famously written and of which you have so eloquently spoken this evening. I don't know if we're all going to assemble in 2025, as we did at Runnymede in 2015, in order to celebrate the 800th anniversary of the statutory force of Magna Carta. Sounds like a great excuse for a party. But your lecture this evening has made the 450th anniversary of this hall a truly memorable occasion, and for that we're deeply grateful to you. Thank you very much.